You are not going to believe what just happened in the courtroom. And honestly, I barely believe it myself. A move that's been decades in the making just landed like a hammer from the sky. For the first time in history, the Department of Justice has formally acknowledged that suppressors fall under the protection of the Second Amendment. That's not speculation. That's not a rumor. That came straight from an official DOJ filing. And just like that, the floodgates opened. Gun counters across the country are already seeing the aftershocks. Shelves are clearing, websites are crashing, and what used to be treated like contraband is now flying off the shelves with the full weight of constitutional backing. If you've ever even thought about getting into the suppressor game, this is the moment you've been waiting for. Before we go any deeper, do me a solid, smash that like button, hit subscribe, ring the bell, whatever you've got to do. It helps keep this content coming and gets the word out to people who care about their rights, their hearing, and the future of responsible gun ownership. Also, drop your thoughts in the comments. I read every single one, and believe me, this topic is going to get people talking. Now let's get into what just happened, because it's not just big, it's transformative. Back in March 2025, deep in the filings for Vanderstok v. Garland, the DOJ did something few expected. They admitted, in no uncertain terms, that suppressors, yes, the same devices that have been regulated and taxed into near oblivion for nearly a century, qualify as arms under the Second Amendment. This wasn't a vague statement. It wasn't hedged in legal jargon. It was a clear, intentional acknowledgement. The federal government, after years of maintaining that suppressors were merely accessories, conceded that these tools are protected just like any other piece of a firearm. And if that's true, then any law that bans them outright is on legally shaky ground. Let that sink in for a moment. For decades, suppressors have been caught in the tangle of red tape from the National Firearms Act, complete with tax stamps, Form 4s, and months of waiting through the ATF's e-form system. They were treated like a luxury item for enthusiasts or a threat to public safety. But legally, the game just changed, because when the DOJ flips its script like this, the whole landscape follows. And make no mistake, this wasn't an act of kindness. This was a strategic retreat, forced by the mounting legal pressure coming from every direction: lawsuits, appeals, public opinion, and a judiciary that's become increasingly originalist in its reading of the Constitution. The turning point, of course, goes back to the landmark Supreme Court ruling in 2022, New York State Rifle and Pistol Association v. Bruin. That decision rewrote the way courts evaluate gun laws. Gone was the old interest-balancing framework, where governments could justify restrictions based on public safety concerns. Bruin said loud and clear, if a law restricts a protected right, it must be rooted in the nation's historical tradition. If not, it's unconstitutional, plain and simple. That ruling cracked open the door. Now, in 2025, DOJ has effectively kicked it wide open. You see, there's no credible historical precedent for banning suppressors. These devices were first regulated in 1934, not because of some public safety epidemic or Supreme Court test, but because of fears about poaching during the Great Depression. That's right, concerns about deer hunting led to nearly a century of suppressor restrictions. But when you hold that up to the light of the Bruin standard, it falls apart. No one in 1791 was wringing their hands about the dangers of a quieter musket. There were no bans on muffling gunfire. There was no tradition of suppressor regulation. And under the new legal standard, that matters more than ever. So, when the DOJ stepped into court this spring and admitted that suppressors are constitutionally protected arms, it wasn't a generous gesture, it was a legal necessity. Their old position couldn't survive under modern scrutiny. The writing was on the wall, and they knew it. So what happened next? Well, you can probably guess. The market didn't just react, it erupted. I walked into my local gun shop the morning after the DOJ filing dropped. The vibe was unreal. Shelves that had been fully stocked with suppressors just days before were almost completely wiped out. The guy behind the counter looked like he'd survived Black Friday. And he wasn't joking when he said orders were coming in faster than they could process them. And it wasn't just anecdotal. Reports started rolling in from coast to coast. Shops in Florida, Arizona, and Texas were seeing lines out the door. Online retailers like Silencer Shop and Capital Armory had to push inventory restock dates forward because their warehouses were drained. Even the big players, Palmetto, Rainier, Brownells, felt the heat. Some dealers reported a 400% increase in suppressor orders in less than 48 hours. Think about that. Months' worth of stock gone in 2 days. It was like the floodgates had opened, and everyone who'd been sitting on the fence suddenly jumped at the chance. And it wasn't just suppressors flying off the shelves. Everything connected to them surged too. Threaded barrels? Gone. Subsonic ammo? Hard to find. Integrally suppressed rifles like the APC-9SD or the Ruger Silent SR series? Sold out. Even pistol-caliber carbines with threaded barrels were suddenly hot sellers. Demand spiked across the board, and dealers couldn't keep up. You could feel the shift, not just in sales, but in mindset. For the first time in a long time, people felt like there was legal clarity. Not total freedom, of course, but breathing room. And that was enough to send the market into overdrive. But while suppressors were getting all the attention, there was another battle being fought, one with massive implications for how the federal government defines what a firearm actually is. That brings us to the ghost gun ruling. The same case, Vanderstok v. Garland, included a challenge to the ATF's controversial 2022 rule on frames and receivers. That rule expanded the definition of a firearm to include unfinished parts, like 80% lowers and DIY kits, even if they weren't functional yet. For hobbyists, home builders, and even some small-time manufacturers, that move was devastating. It turned a huge number of law-abiding people into felons overnight. Suddenly, a polymer hunk of plastic that hadn't been drilled or assembled was being treated as a regulated firearm. That's where the Supreme Court stepped in, and in 2025 they made it clear the ATF had not overstepped. The court upheld the agency's authority to regulate these readily convertible parts under the Gun Control Act. It was a blow for the DIY crowd, no question. But what it didn't do was undo the momentum behind suppressors. In fact, what's happening now is a separation of categories. Courts and the DOJ are beginning to distinguish between firearm components like frames and receivers, which can create an operable weapon, and accessories like suppressors, which enhance safety and usability but aren't weapons themselves. And that distinction is starting to reshape how buyers think. Because it's not just die-hard gun collectors driving this surge. This wave of suppressor sales is different. Talk to any dealer right now, and you'll hear the same thing. The crowd is changing. First-time buyers are coming in asking specifically for suppressor-ready handguns. Parents are looking for bolt-action rifles that won't blow out their kids' eardrums at the range. Hunters, especially those in more rural areas, are starting to treat suppressors as standard gear, not luxury add-ons. The idea is catching on that suppressors aren't scary. They're practical. And in some places, they're seen as basic courtesy. Think about it. In the same way, seatbelts became a default expectation in cars. Suppressors are becoming the expected addition to any modern firearm. They reduce recoil, protect hearing, and make shooting more enjoyable and safer for everyone involved. Older shooters are coming back to the range with suppressed builds because, after years of shooting steel with no hearing protection, the damage is real. Families want to teach the next generation in a safer, more controlled environment, and plenty of first-time buyers are jumping in not because of some tactical fantasy, but because they see suppressors as a responsible upgrade. What used to be a niche, reserved for hardcore NFA collectors, is now mainstream, and it's all happening fast. But here's where it gets even more interesting, because this isn't just playing out at the federal level. That DOJ admission? It's already being weaponized in courtrooms across the country. Take New Jersey, for example. That state has one of the strictest bans on suppressors in the nation. Until now, challengers struggled to get traction against it. But with the DOJ's recent filing in Vanderstok, that legal wall just started to crack. Gun rights advocates filed a fresh lawsuit. Padua v. Platkin, using the DOJ's own words to argue that New Jersey's ban is flat-out unconstitutional. That's not just a clever legal move, that's flipping the chessboard and using the government's own position as a battering ram. And it's not just New Jersey. Legal teams in Massachusetts, Illinois, and New York are already laying the groundwork for similar challenges. The legal logic is simple. If suppressors are arms under the Second Amendment, and the DOJ now agrees they are, then states that continue to ban them are likely violating the Constitution. The pressure is real. Lawmakers in several restrictive states are already signaling they may step back from supporting suppressor bans. Why? Because they can see where this is going. Courts are aligning with history. The Bruin standard is being applied, and state-level laws that can't withstand that scrutiny are falling one by one. For the first time in decades, we're watching the potential birth of a nationwide shift in how suppressors are viewed, not as contraband, but as tools that deserve the same respect and protection as any other firearm accessory. This moment isn't theoretical. It's happening now. The market has already moved, the courts are moving, and everyday gun owners, people like you and me, are at the center of it. So, what does this mean for you? If you've ever thought about owning a suppressor, this is probably the best moment in your lifetime to make that decision. The legal landscape is clearer than it's been in years. The stigma is falling away, and the tools that help protect your hearing and make shooting safer are no longer seen as suspicious. They're seen as common sense. But let's be real. The battle isn't over. There's still the NFA tax stamp. There's still Form 4 wait times. And there are still states where law-abiding citizens are blocked from owning basic hearing protection that's legal in 42 others. That's why now is the time to stay sharp. Get your paperwork in order. Pay attention to your state's legislative sessions. Support the legal organizations pushing these challenges forward, because this moment, this window we're in right now, isn't guaranteed to stay open forever. If you're in a free state, you've got options. Integrally suppressed bolt-action rifles for hunting. Subsonic-capable home defense setups. Pistol cans for your EDC that won't blow your eardrums in tight quarters. Suppressors aren't a luxury anymore. They're part of the modern toolkit. And if you're still on the fence, don't wait until the shelves are empty again. Don't wait until the laws shift back. Don't wait for permission to exercise a right that's already yours. Now, before you go, make sure you hit that subscribe button, smash like, and drop a comment below. I want to know how you're feeling about all this. Are you already a suppressor owner, planning your first, or still waiting on that Form 4 to clear? This isn't just some news cycle, this is a shift, and we're only getting started.